We're going to proceed with the next panel. The solicitor-client relationship, which I guess, from what we've heard already this morning, is probably the key to many ethical and practice issues. First, to my immediate, or to my far right, is Mark Orkin, who's been actively involved in law for, well, how many years, Mark? It says in the materials that you will.
Classified.
It's classified, is it? Maybe we can pull your Law Society records here, Mark.
Probably.
Okay.
I'm still paying fees.
Okay. Well, maybe a hint. What was your first fee you paid?
Quite small.
I see. Okay. You've written 2 texts, Legal Ethics and the Law of Costs, lectured extensively, and you're probably an ideal person to talk about the role of a lawyer, especially, I guess, the role of a lawyer in 2000 and beyond, and what kind of obligations are increasingly imposed upon the legal profession. People here will recognize Robin Seligman, who's the chair of CBAO Ontario, and I understand will be again. Robin's been active in many issues related to the Ontario Bar, and for everything from legislative changes to lobbying, and also trying to maintain her own practice at the same time and struggling with these similar solicitor-client issues. And so you've got a good panel here to address what it is you should know in your practice. Thank you.
Thank you, Howard. Mark's going to lead, and what I wanted to say is we want to keep this as open as possible. I'd like to keep things casual, so if anybody has any questions while we're talking, please feel free to interrupt, and we'll play it by ear. So, Mark?
Thank you. Well, just picking up on the last remark that Howard made about me, I'll give you one more hint. When I was a law student, they paid me $6 a week. So it went up the second year. As you can see from the printed material, the subject that Robin Seligman and I are supposed to talk about this morning is the solicitor and client relationship. And that seemed like a pretty broad field when Robin and I first talked about it, and I thought we should come up with a catchier title and one that would better reflect our different takes on the subject. I've never practiced immigration law. Robin is a very active practitioner in that field. And I thought that a better title might be something like A View from the Hill versus Life in the Trenches. That would let me talk about theory and let Robin talk about the blood, sweat, and tears of an immigration practice. So if that's agreeable with you, Robin,
That's
let's
great.
do it that way.
Great.
But theory aside, members of the immigration bar, like all of us, of course, have to live in the real world, and they have to face the facts of life. The only difference is that for immigration lawyers, the facts of life are somewhat different than those, for example, facing a lawyer practicing real estate in North Toronto. The circumstances are different, the pressures are different, and the problems are different, and they're more serious. The first fact of life that you have to deal with is that the relationship between the practitioner and immigration consultants or agents has been touched on here, and it's one of the main things that I'd like to talk about this morning and how one should deal with it. In many situations, the need for consultants or agents or whatever one wants to call them is perhaps necessary, perhaps inevitable. Your client is thousands of miles away in Moscow or Shanghai or wherever, or places in between, speaks a different language, which you can probably neither speak, read, nor write. So that points one in the direction of some kind of intermediary who can communicate, who can be the bridge, the channel between you and your clients. The question becomes, how do I deal with, first of all, do I deal with immigration consultants, and if so, how? And I know many lawyers say flatly, I do not deal with or through consultants, period. And that's their decision, and who's to say whether they are right or wrong in their particular context. But if you do decide to deal with them or through them, then I'd like to outline some of the ways that I think you can do that and protect yourself. The second fact of life that you have to cope with is, as I said, was geographical. Not only do you have difficulty communicating with your client because of the language difference, but because of the spatial or geographic difference. They're thousands of miles away. Like my hypothetical case of the real estate lawyer in Toronto, his client can jump on the subway and come down to his office. Very hard to make personal contact with your client when he's 3,000 or 5,000 miles away. Again, points to the consultant-agent nexus. The third fact of life is how you make contact with your client in the first place. How does he find out about you or she, let alone retain you, when because of the geographical and linguistic problems? Again, you have the problem of your ever helpful agent consultant. Fourth fact of life, your client may reside in a country where it's dangerous, even an offense, to make any overt move toward emigrating. They're often unable to communicate freely with you. The last thing in the world they might want is to have a letter come from a Toronto or Ontario lawyer to their particular town. How do we avoid subjecting them to those kinds of risks? Again, the consultant agent. So each one of those situations points in the same direction. And that brings us to the last and maybe hardest fact of life, and that is that you as an Ontario lawyer are subject to the rules of the Law Society as to your professional conduct and to the tender mercies of the assessment officer as far as your fees are concerned. The consultant is subject to neither of those restrictions. He's under no supervision by anybody that I've ever been able to find out, either as to his conduct or as to his fees. And that potentially, at least, could put you in a very precarious situation. The problems involving immigration agents aren't new. At least 20 years ago, the Law Society studied the matter, made recommendations to the then Minister of Immigration in Ottawa, recommending on other things, among other things, that immigration agents should be under some form of regulation, and that they should work under some kind of supervision by the lawyer involved in the case. That part was a little vague. The recommendations seemed sensible at the time, but nothing was done. 5 years or so later, there was a further set of initiatives taken by the Law Society. This time they were addressed to the Provincial Attorney General of the day, dealing with people who, dealing with the provision of services by unsupervised advisors or consultants, including immigration consultants. And it pointed out that members of the public were often at the risk of unscrupulous consultants, and that they should be regulated. The Attorney General's office thought that was a good idea, but it won't surprise you to know that nothing happened. The thing came around a third time a couple of years ago when again the feds intervened and set up a parliamentary subcommittee on the subject. Representations were made by the Bar Association, by the Law Society, by a lot of other people, and the committee concluded that yes, this was indeed a very serious problem and something should be done about it, and nothing was done about it. So it shouldn't surprise you that the more things change, the more they stay the same. Most recently, the matter has come up before the Corey Commission, and again, this gave us all another kick at the can, and representations were made. The commission is supposed to deal with paralegals, and while immigration agents may not sound at first blush like paralegals, in effect that's what they are, or at least that's what part of their function is. So submissions have been made, and it remains to be seen what will result. But looking at past history, it doesn't sound very hopeful.
Mark, if I can just add a few comments in that regard, because I did appear on behalf of the bar in front of the previous Justice Corey, and the bar's position was actually very extreme. It covered all aspects of the practice of law, including immigration, criminal, family, etc. In the areas of criminal and immigration, the Ontario bar's position was that consultants or paralegals should not be allowed at all to be in the field unless they're under the direct supervision of a lawyer, which is a very hard line. And Justice Corey was quite sympathetic. Even the paralegals making the submissions were all in support of regulation. So at a minimum, we hope to see recommendations for regulation. But again, I agree with Mark, the reality of anything happening is not, we don't know. It's been very unfortunate history. In addition, any regulations that they would come out with do not affect overseas practice, which, you know, in the area of our area of law, it's huge. It's probably bigger than even inside Canada, which is a problem. And in terms of the Department of Citizenship and Immigration dealing with the issue, we've recommended on so many occasions that they adopt the American system of before the American Department of Immigration will deal with any representations, it has to be from an American lawyer. Actually, they have a special form, I think it's a G28, and it has to be submitted before they'll even communicate with you. We've recommended the same thing. The department has not been receptive to that. We don't know why. So we said, at a minimum, make sure that anybody you communicate with is a Canadian citizen or permanent resident. They said, yeah, well, and it's not really followed, although in theory that's supposed to be what's happening. So on overseas applications, if it's just a consultant who's not a Canadian citizen or permanent resident, theoretically the government's not supposed to communicate with them at all. But they do. Yeah. I was just going to add in that most lately, and Michael Green, who will be here later on, can comment on that, the department has come out with a very strong statement that's supposed to go out with every application form, like a little brochure on representatives, and it was quite offensive when it came out. It was basically saying, really leading to the impression that lawyers and consultants are, first of all, the same, in the same league, and that there's a lot of misrepresentation of fraud created by lawyers and consultants, and this is who you can complain to. And they gave the Law Society information for lawyers and the Better Business Bureau for consultants. So we obviously, ranted and raved about that. They're still coming out with a pretty nasty brochure that's going to go out to everybody. So we said, at least if you're going to put that brochure out, why don't you make it very clear in bold letters that we will not communicate with anybody who's not a Canadian citizen or permanent resident. You think that would be so obvious because under privacy legislation, they're not allowed to. We don't think it's happening. So, you figure it out. It just doesn't make sense, and it's very frustrating, but you're left with situations where these consultants and paralegals are making applications overseas. They have no connections to Canada. They have no commitment to the truth, or, they're encouraging people to present fraudulent applications with no accountability, and it's very frustrating, as you know, to be thrown into the same basket as these people being called representatives. So that's the state of affairs. Nothing's really progressed. And nobody knows why. Yes.
It was interesting. I was overseas hearing the consultants discussing this. I don't think they knew at all what it was. And they said, well, if they put something in, we're simply going to ghostwrite it. So a little period came in from the applicant, even though they prepared everything.
Yeah, the American law actually has prohibitions against that, and I think actually under the... Yeah, that's the real. But at least, if an applicant receives something saying, we will not communicate with someone unless you're a Canadian citizen or permanent resident, make sure that your representative is a Canadian citizen or permanent resident. At least it's something. At least it's a red flag for someone to, if they can read in their own language as well. It would be nice if they put it in, besides English, they might put it in Chinese or, the language that people would be able to read. It's a big problem. So go ahead, Mark.
Good. Well, for some reason, I agree with Robin. For some reason, no government seems willing to come to grips with this, and as an outsider, I can't imagine why. What is the objection? I've never heard any valid or cogent objection to doing something like the American system, but where it works.
All the senior officials in immigration, when they leave, want to become consultants.
Yeah, that's a practical, yeah.
Helpful. Helpful.
Yeah.
Helpful.
It's always the issue also because it's federal legislation and the way you carry on business is provincial.
At least they would be Canadians and probably or possibly Canadian residents. I think the thing could be framed in such a way that they would placate that gang and still put in some measure of control where today there's none. Anything would be an improvement, surely, over the present situation. So my thinking is that the next thing I wanted to say is that if for whatever reason, who cares what the reason is, if governments don't want to do anything about this, then it seems to me that the members of the immigration bar themselves have to take necessary steps to protect their own integrity. And that's let the government do as it pleases, when, as, and when. So it seems to me that certain things have to be done, and there some of the material that we filed, regrettably Robin and I have not put in papers, but I can blame her and she can blame me for that. But first off, I think it's essential that you paper the entire transaction. The blurb rather dramatically says from the womb to the tomb. I'm not sure how either of those fits in, but in any event, there has to be something in writing that can be applied to every stage of the relationship. And that means that, first of all, there has to be an agreement between you and your client. There has a retainer agreement. There has to be an agreement between you and the consultant. And thirdly, not essential, but I think necessary, there has to be an agreement between the client and the consultant. All of that in writing.
And in your materials, there are basic agreements that
That's
you,
right.
you might want to change around or use for precedent.
And you have to keep in mind always that the prospective immigrant is your client, not the consultant. Never. The consultant is never your client. Now, the first agreement is your retainer. Broadly speaking, you should always, not confined to immigration law, you should always have a written retainer agreement with your client. But I think it's more important, perhaps, in the case of immigration clients because of the linguistic and geographic and other problems that we've looked at before. Your agreement with your client should set out a number of things. The forms that we've attached, they're not written in stone. Do anything you like with them, but the basics are these. It should define that you're being retained to make application or to act as legal counsel in applying for status in Canada. That's the first thing. Secondly, if it's applicable, if you're using an agent, then you're authorized to retain an agent to do certain defined duties, such as translating documents, gathering information, assisting in the processing of material, that kind of thing, compiling information, medical, financial, whatever it may be. The third thing it should stipulate is that you will be paying the consultant a fee for services rendered. And fourthly, it should set out the fee arrangement between you and your client. That's step number one. Secondly, you should have an agreement between you and the consultant, which would do these things. A, it would specifically define what the consultant is going to do. The services that he's going to perform, whatever they may be, translation, gathering, compilation of material, preparation of forms, whatever it is. And most important, it should make clear that there isn't going to be any division of fees between the lawyer and the consultant. That last provision is important in light of the Law Society rule about the division of fees with non-lawyers. Gavin MacKenzie touched on that earlier. The rules are all there, but I might just refer to them very, very briefly because the text is significant. The present rule is Rule 9, Commentary 7. It reads thus: any arrangement whereby lawyers, directly or indirectly, share, split, or divide fees with conveyancers, notaries public, students, clerks, or other persons who bring or refer business to the lawyer's office is improper and constitutes professional misconduct. It is equally improper for a lawyer to give any financial or other reward to such persons for referring business. That's the present rule. And it's not really as comprehensive as it might be despite its length. And it probably applies to the lawyer-immigration consultant relationship that we've been talking about. The new professional conduct rule, the proposed new professional conduct rule, is simpler than that and clearer. It's now going to be Rule 2.08 sub 9, which is short and sweet, and it says, A lawyer shall not, directly or indirectly, share, split, or divide his or her fees, or give any financial or other reward to conveyancers, notaries public, students, clerks, or other persons who are not lawyers. Now, that certainly spells it out. You might be wondering about that word, about a reward to conveyancers, or others. I don't think that would interfere with your hiring a consultant and paying him a fee if he's doing something. It certainly would prevent you from splitting a fee if he does nothing. Thirdly, you should paper the arrangement between the client and the consultant, and there's a suggested form in the material. I would recommend that you have a written agreement with the client, between the client and the consultant, in which the client does these things. First of all, it authorizes and instructs the consultant to prepare and transmit documents to the counsel, to you. Secondly, the client should acknowledge in the agreement that counsel will be paying the consultant a fee for that work. And thirdly, if applicable, it should provide that the client authorizes that all communications from Canadian Immigration and from counsel be forwarded to the client in care of the consultant. That's important to get the routing of paper and to get an authorization from the client as to that. Now, those three agreements between the lawyer and the client, between the lawyer and the consultant, and between the client and the consultant, I suggest you are the three essential pieces of paper that you should have in order to cover this transaction. And let me suggest a further precaution. Since in many cases the mother tongue of the applicant, your client, is not English, then it's absolutely essential that all relevant documents be translated into the language that the person reads and understands. That way you can never be faced with the problem farther down the road that the client didn't understand what the respective responsibilities of counsel and consultant were, or what the client's obligations are to each of them. And a further point, you should never lose sight of the fact that in many situations the immigration agent, consultant, whatever he calls himself, will be your agent, with all that relationship implies. Now, I'm not going to give you a short course this morning on the law of agency, which perhaps you know better than I do, but you should bear in mind the basics of agency law, which simply put are that the agent's duty is to follow the principal's instructions, to exercise care and skill, to act in good faith, and to make full and fair disclosure at all times. On the other hand, the liability of the principal for the agent's fraud and misrepresentation is equally clearly defined in law, and that is what you have to bear in mind. A principal, of course, would not be liable for the fraud or misrepresentation of the agent who's dealing in matters beyond the scope of the agency, unless, of course, you have expressly authorized the acts to be done, which you won't do. The law of agency, of course, is much more complicated than that, but I wanted to raise it so that you will bear in mind that this is a very significant factor of the relationship. However, you know, paperwork can only go so far. As somebody has said, well, so you get all these agreements signed, how are you going to enforce them? And the truth of the matter is that is an essential weakness of any piece of paper. It's no better than the good faith of the parties and their willingness to enforce it. But I think the important part, paper aside, and paper can't help you here, is to make sure that you don't become the dupe of an unscrupulous immigration consultant or indeed of a dishonest client. Which leads me to a further matter that I want to mention, which is that, in my opinion, members of the immigration bar should not represent people who put forward manifestly unfounded claims. To my way of thinking, to do that is not at all on a par with representing somebody who's accused of a criminal offense, although some people have tried to analogize between the two situations. I don't think it's so. In the latter case, the fact that the person charged may actually have committed the crime has absolutely nothing to do with your representation. It's for the court to decide on the evidence whether that person is guilty or not guilty. And your knowledge or belief in the case has absolutely nothing to do with your representation. Now, to my way of thinking, that in no way resembles the situation where the client seeks to put through you some improper or fraudulent claims. And I think there can't be any doubt in the matter that as soon as you become aware that that's happening, you must cease to act for the client. If you don't, then you're becoming, in effect, a kind of accomplice. And there have been several cases in recent years where lawyers have been caught in that trap and been censured. And I think that, you know, it's fair to say that no fee is worth running that risk. I began by suggesting that a better title for our talk today was The View from the Hill versus Life in the Trenches. That gap, it's more like a canyon, really. It's something that you have to be mindful for throughout your practice, because all the perils that are common to your line of work are there. All I can say after you've done the paper and everything else is to always to remember to cover your back. In closing, if I were asked how a lawyer should handle the relationship between himself or herself and immigration consultants, I would remind you of the old joke about how porcupines make love. Very carefully. Thank you. Robin?
I'll just add a couple comments in there. Maybe we'll take some questions. You know, in reality, a lot of times people are coming into you, or if you're dealing with, you know, consultants overseas, because this covers, I guess, consultants and your solicitor-client relationship, you have to take a step back, and it's easy to get caught up into wanting to do the business and wanting to promote your practice. But I really think you have to take a step back and always go back to the basics. You have to remember to tell your clients to tell the truth. And sometimes, you know, people are so busy making up stories and listening to what their friends tell them and what their friends tell them. And I think, you know, common sense should tell you when something doesn't sound right, it's probably not. And a lot of clients come in and I think they do lie to you, thinking that it's just sort of a white lie and it's not that important. I always make sure I tell my clients in every meeting, please, I will not act for you if you do not tell me the truth. And I make it very clear to them that I am not the government. A lot of people are afraid to tell you the truth because they're not really sure of how you fit into the process. And I make sure I tell them I don't work for the government. I'm an independent lawyer. I want to see if I can help you, but in order to do that, you must be honest with me at all times. And I make sure in my retainer agreements I very clearly put in there, if you are not honest to me, I will unilaterally cease to be your lawyer. And I think for a matter of your integrity, your reputation, and for the promotion of your business and your future as a lawyer, don't forget that. You may want to just, I always keep this in my mind, how would I be responding, what would I say if this conversation was being recorded? And, you know, would I want to be saying some things that I'm saying if it could be played back to me? And I think you should really keep that in mind. You have to be very careful. And, you know, we're all aware that our clients today could become our worst enemies in the future. And just no client is worth it. No client is worth it. And if you suspect that something just doesn't sound right, don't ignore it. Ask them the questions, pursue it, and make sure you get to the bottom of it, because there's so much nonsense that goes on in our field. You know, typically, let's say marriages of convenience. People come into you, oh, I'm married and this and that. I don't just accept that people are married. Unless it's very clear they have children together, and you know, you can usually get a gut feeling of whether it's a bona fide relationship. And I'm talking about humanitarian applications inside Canada, humanitarian applications, for example. I ask questions. You know, when did you meet each other? Where did you meet each other? I mean, if any of you have done these humanitarian interviews with immigration, they separate the spouses and they ask all kinds of personal questions, not offensive necessarily, but, you know, what side of the bed do you sleep on? You know, who's closest to the window? How many alarm clocks in the room? You know, stuff like that. And I ask those types of questions to people if I have any feeling that, you know, this doesn't seem right to me. And if a lot of times people come into me and blatantly say, well, this is a business marriage. And the first thing I say to them, there is no such thing as a business marriage, that's fraud. And I make it very clear because there's a lot of people within their communities that are telling them this is perfectly legitimate. It's perfectly legitimate to lie about that, and their friend got away with it, so why shouldn't I try it? So you really have to be careful in your position to just don't get into that. If you suspect that it's not for real and it is not for real, I will not act. I mean, if they want to go to a consultant and have them represent them, I warn them against it, but I say, I'm sorry, I can't be party to this. If you want to make a proper application and not misrepresent any relationships, I'd be happy to try and help you. I always tell people what their chances of success are. I can't give them a number, but I tell them that on humanitarian applications, based on my experience, if it's a legitimate spousal application, you should not have a problem. But if it's something other than that, I tell them, what I think the chances are. As best as you can. I always make sure I tell people I am not guaranteeing it. I even put that in my agreements. I will not guarantee the success of this application. There is so much temptation out there to not act honorably because your competition, especially overseas, well, I shouldn't say everywhere, inland and overseas, people are giving guarantees, consultants. They're giving guarantees, they're giving money back guarantees, they're doing no money down. It's almost like you're in one of those Leon commercials or whatever, don't pay a cent or whatever. My position is you just don't get involved. You just don't do it. If someone says to me, well, and typically, let's say in China, this is happening a lot. Well, we don't have to pay any money, and the lawyer pays for this, and the lawyer pays for that. I just say, I'm sorry, I'm in a different league than that, and I don't participate at all. So it's very tough, though, when you're trying to develop a practice and you want to promote clients, but it's just not worth it. You have to deal with people that are reputable and credible, and what you do today affects what will happen to you in the future in terms of your reputation. So you have to be very careful of that. Typically, a situation that arises is an ex-client will come to me and say, I want to refer business to you. How can I get involved? You've heard from the rules, you can't pay a referral fee. What I do in those situations is I get the client involved. If they want to refer business to me and get paid, they have to do work for it. And I teach them, I train them to the best of my ability. I mean, if they're not on staff, you can't spend an exorbitant amount of time training people, but you cannot pay for just referrals. So if they want to translate, if they want to collect documents, if they want to communicate, get it in writing, and you can pay them a reasonable fee for those services to be rendered. So that's how I would deal with sort of the one shot, or whenever it comes about. They don't necessarily have to be on your staff, but they are still acting as your agent, and all the rules that Mark mentioned applies. So I would keep that in mind. In terms of one of the topics covered on here is actually what to do of non-payment of accounts and withholding visas, and we've had discussions about that, and it's just totally unacceptable. You are not allowed to hold back someone's visa because they don't pay your fee. So you have to, I guess, work out your own payment arrangements so you're least likely to encounter that situation. Typically, the situation arises when the visa posts send the visa directly to the client. It's a problem, especially when they're over there and you're over here and they haven't made their final fees, but you're stuck with it. I mean, unfortunately, you lose money unless you want to litigate and pursue people overseas and try and get an award or a judgment, which is not likely. The best way to control that is to take your fees fairly. I know personally what I do is I take half the fee to begin with, and I take the balance of my fees when the clients know that their interview's scheduled. And I tell them if for any reason you don't pass other than fraud, etc., I am willing to refund that money. And the Law Society has written a letter, and it appears in your materials that that's okay. They don't consider that, I guess, a contingency fee, although I think probably technically it is. But I think in our area of practice, it's a reality, and you don't want to take the full fee necessarily if the person doesn't get their visa, even if it's not anybody's fault. It's a lot of money for people to be paying, and sort of on a humanitarian basis, you will say, I don't want that money, and in good faith, I'm giving that back to you because, maybe we'll try again, and I don't hesitate to give that money back because. If and when those situations arise, even if it's the client's fault, they lied about something or whatever, I don't make a big deal about it because the good faith that you develop with that client by not keeping that final fee is well worth it, because they will not hesitate to refer friends and other friends, because even though they didn't pass, you're honest with them. And a lot of times it's nobody's fault that they didn't pass. They had a bad visa officer, they didn't mention something that they should have mentioned, so they don't necessarily blame it on you, and you will get more promotion and more business out of that by being generous by refunding that second payment. So that's how I personally do it. Other people take it in 3 steps. Other people, people do all kinds of things. The ones who get their money up front, I don't know how they do it. I don't, in today's business world, I just don't think it's a reality, but I have spoken to lawyers that do that, and good for them. So subject to those few comments, are there any questions that people have? Yeah. No. I don't have a problem with what you're saying as long as you're honest with the person. I think as a lawyer you're obligated to tell them of all their rights. And one of their rights is if you tell them what a refugee is, a convention refugee is under the existing act, and you tell them in your professional opinion you do not fit into that category, and notwithstanding that you have the right to make that claim, and as a result of that claim certain things will flow. For example, they will not immediately be removed from the country. They will be entitled to health insurance. They're entitled to work. That's a decision that the person has to make. Personally, I advise people of those rights, and in most situations I will not represent them. And I tell them I don't think you'll win the claim. It's my opinion that I don't feel comfortable appearing in front of the board from someone from this country, although there's unusual circumstances. For example, I've had people from Trinidad or Guyana where typically they would not be refugee claimants, where they are abused women, and they have been successful on their refugee claims because they fit into domestic abuse where the government is not willing to help them, and in those countries they chop up women with machetes or whatever. So, but I'm just saying, but those are typically countries where you wouldn't think that people are, that the statistics show that there's hardly anybody that would ever be approved in those countries. So, but in situations where it's just, I don't want to go back because I can't find a job, I personally would not represent them, but I would tell them that they have the right to make that claim, because they know they have the right to make that claim, and you shouldn't be, I think, hiding that. Yes? I'm just saying that's my personal opinion, but I don't think there's a problem if that person says, I don't care if you tell me I'm going to lose this case, I want to be represented. I don't think there's a problem with you representing them. Well, I think he was talking about overseas applications where the person submitting, or the person has no chance at all of winning. What if someone, on the independent system gets 60 points and there's no way in the world that they can pass? I think it would be totally unethical to take the case and submit it and take the fees. Well, you know what? I don't think people overseas really understand what it means when you say no sometimes. I think, well, maybe there's a chance because their friend got through. Unless it was somebody where like discretion would work in a positive way, that they're already in Canada, they have a job, or they have some unusual circumstances, a humanitarian case, I think it would be inappropriate to represent. Even if they say, I don't care, let's say someone has no ties to Canada, their points are way too low, their English is lousy, and there's just no way they're going to get through, and there's no reason that you would think that it's a humanitarian case or a discretionary case. I personally think that would be unethical to take their money and represent them when you know they're going to fail. And they're spending probably half their life savings. Personally, I think it's unethical. I don't know, someone Mark may want to say in terms of the rules. Barbara, what do you think of that? Yes. Yeah, they're in the system. But in terms of initiating an application overseas where there's no chance in the world they're going to succeed, there's no humanitarian, there's no 11-3 discretion, their points are way too low, they don't speak the language, they're just, say, I'll just take a shot. I think you're crossing, you would obviously document that very carefully, saying there's no way in the world you're going to pass, but you want me to represent you, fine. I probably think you don't run a conflict to the rules of professional conduct. I think you run into, personally I have a problem with that, but, I don't. Mark, do you have any comments on that?
I would agree with that. I think you have to distinguish, first of all, the fraudulent cases. There's just no question about that, obviously. The next, I suppose, is the the hopeless cases. And again, I don't think there's a question. I agree with Robin on that. I think, notwithstanding what the client says, clients are, you know, the first lesson you learn in law is that clients never want to be told that they can't do something. They want to be told how they can do it. It's an old joke that you teach to your students. But if the case is hopeless, if there's absolutely no possibility of success, then I don't think you've discharged your onus simply by your ethical onus by simply telling them your case is hopeless, don't do it. If you then proceed to do it, then you're in a way saying to the client, well, maybe there's a way around this, but if truly there isn't, then I don't think you're being honest with the client or honest with yourself, and I don't think you can do it. The fact that somebody else might take the case isn't the answer.
And remember, you're dealing with people in third worlds or countries where bribing is a way of doing business, and I think there's sort of a tacit expectation from that person, or an implied expectation that maybe there's a way to get around the rules and you know about it because you're a lawyer. Even if it's not spoken, I think that it's there. People will say it to you blatantly, well, come on, there must be some way to get around this. And you say, sorry, there isn't. You know, this is the way it is, and these are the points. And I mean, I personally think it would be just unacceptable to take a case where you just know it's just, there's no way that person's going to win. And as Barbara said, if someone's here being deported, they have no choice. They have to be represented, but they do have a choice overseas whether to initiate that application. I just don't think your name should be associated with. It doesn't reflect well on you in terms of the visa offices. No matter what you tell that client, they're going to blame it on you. You're going to get no more business from that person in the future or any referrals. So what's the benefit? It's sort of like short-term gain for long-term pain. You've ruined your reputation as far as I'm concerned. The visa officers know who hand in loser cases and who are. It almost appears like you don't know what you're doing. Gary.
Mark, I have a question with respect to your comments on section 208, paragraph 9, these words. And my comments relate to the fact that trenches as opposed to pyramid. The fact is, and I don't want to talk about the results, but agents, people that you train, people basically paralegals abroad, working out there, not on a salary basis. The reality is that there is a peace split of some sort in this principle of services. The law society has walked 20 years ago. I have a question. If you look at section 208 sub 10, here's page 46 of the rules. It says, sub-rule 9 will modify the multidisciplinary of lawyers and non-lawyer partners with partnership agreement provided for sharing the profit. Why can't you, if you have an agent in Iran, an agent in China, an agent somewhere else that you train, if you're supervising, not a limited retainer situation, and they're doing all this work, why can't you enter into an agreement, slightly different from the limit shown in the book here, it's a partnership agreement with respect to those non-lawyers, with respect to the services that they're going to provide into the police?
Well, in principle, I guess you can, but if it were me, I would send a copy to the Law Society and say, is this okay? Is this within the rule, or is it not?
Rule says non-lawyer partners, doesn't talk about that they have to be accountants or they have to do anything else. I've asked Gavin about it, he says non-lawyers is non-lawyers.
Yeah. Well, the rule just doesn't cover your situation precisely. It isn't spelled out.
20 years they've refused to deal with the situation, maybe now they've left a loophole.
Well, I guess it's worth trying, but as I say, you know, I can't see any other interpretation.
10 lines, what, 20 words long?
Oh, well.
Lawyer,
Could I make a comment on that?
Lawyer's language.
I suspect that the use of multidisciplinary in that rule relates back to the creation of a multidisciplinary entity by the Law Society, which is the joining together of two law firms.
No, it can be a law firm and a law firm, it can be a law firm and psychologists, it can be law firms and anything.
A law firm and an accountancy firm cannot join together.
For multidisciplinary?
Yes.
Signing them, right? With Arthur with whatever it is, Arthur Anderson. It's exactly what it is.
There,
Yes. A law firm that has a partnership agreement with a multinational accounting firm.
okay. Well, I just want to be careful not to discuss the Ernst & Young and Donahue scenario too detailed here, except to tell you that that is the Law Society views that as a captive law firm, but two separate entities and so Donahue must maintain an entirely separate entity in terms of its clients, confidentiality, and conflicts of interest. I'm just suggesting to you that I know what reading you're taking from it, but I think I think there's a larger context to it. I think the Law Society has defined what a multidisciplinary firm is. And so I just point that out. Okay.
Is that page 27?
Okay.
Howard, if I could, if you look on the website, they clearly you probably could do that very campus. I don't think that that's necessarily incorrect. If you want to set up, we do set up 25 engineers all over the world. And also, the people that work with you are under the, well, more than supervision from where they're working. So you have to follow the parameters of the and you have them. That's what it is. In conjunction with what
And I just wanted to comment on one matter that you said, Robin, only because I saw that Jean Roberge, you either seemed to pique his interest or someone, the Director General of Immigration is interested, I'm interested. It was on the issue of retaining a visa or holding a visa. And I just wanted to throw out another interpretation to that, which you might want to comment on, because that's been a fairly serious issue and was one of the, I guess, motivations in the new operations memorandum, which will be talked about in terms of what who the department could respond to in terms of directions from clients and lawyers. I believe, my understanding of the law is that I can hold a visa. I can apply a solicitor's lien to a visa and hold that visa as property of my client pending a properly provided account for services rendered. Now, the issue then, and I can actually do that under the current Rule 8, subsection 10. So I can do it two ways. I can do it because common law gives me rights to do that for centuries. And in terms of determining what my professional responsibilities are in this jurisdiction, I can do that subject to having due regard to my client's position. So I can't hold that visa if it's going to expire in 10 days or for that matter 1 month to the detriment of my client. But if that visa's got a life in it of 11 months, well, I'm allowed to use that in terms of saying I've got your visa and you in turn have not paid me my fees.
I don't disagree with that, actually. I was thinking more in terms of you cannot, the client says, I'm not paying you, I mean to permanently keep that visa or send it back to the visa office because they don't pay your fees. What you don't want to get into is a situation where the visa is expiring and you don't give it to the client because they haven't paid the fees. But if, I don't think it's a problem if it's used sort of as a bit of leverage, I guess you'd call it.
Right.
When there's ample time for them to use the visa to say, oh, by the way, your visa's in, my final fees are due in accordance with our retainer agreement, and I guess work from there.
And I guess that point will tie in a little bit to the discussions that will follow, because it's a very, very complicated process to figure out at what point you should release that visa because you're causing prejudice, keeping in mind that at the time those visas were issued, those children may still be dependent children, but now those children are not. And so if that applicant forfeited that visa for any reason and had to restart the application, children may not be inside the application anymore. There's lots of things that could have transpired over time, especially in processing in offices like the PRC in India. And so you got to be really careful that harm you cause is just not inconvenience, but fatal to the application. The other side of the coin is you don't want to work for nothing either, and have a process circumvented where your client says, I demand the visa from you, and no, I'm not giving you payment.
But I guess in reality, I mean, I've been practicing for 15 years. There's not too many times that I call clients, say, I have your visa and do you want to make your final payment, that someone says, no, thank you, I changed my mind, I don't want to pay you. I mean, it's theoretically something interesting to discuss, but I think on a practical basis, if the person doesn't want to pay for the visa, most likely they don't want to immigrate to Canada anymore. And when that situation arises, they've told me, can you please return the visa to the visa post? I want my right of landing fee back, and I don't have a problem with that. I guess I would never, no matter whether I was allowed to or not, hold that visa if it prejudiced the client in the long run. You know, I just wouldn't want to be responsible for that person, the visa's expiring and them no longer qualifying for permanent residence because I was holding on to that visa. I like to get rid of them as soon as they come into my office. Yes. Yes, I think it is. Until it would be released directly to the client. Well, mind you, even right throughout, it's almost like a passport. Yeah. Yeah. It's not the same. I don't think it says on it it's the property of the Canadian government. It's not the same disclaimers as passports. No, they cannot recall your visa at will. They'd have to go through an inquiry, and you have appeal rights, etc.
Just on that issue, what's your obligations when you get somebody who calls you up and says, I was just told by immigration last night that I'm no longer a permanent resident. They landed 10 years ago, who haven't come back, did not voluntarily give up their permanent residence, did not go through did not have an adjudicator, did not have a...
Where's the person at the port of entry, or the person's overseas?
They're overseas, and they ask you right now, am I a permanent resident or am I not?
My answer is you're a permanent resident till your status is taken away. No, but the only person that can make that decision, no, the onus is on you. It's a reverse onus. And when you enter the country, the only people that can take that away is through the inquiry process, an adjudicator, and the rights that flow from that. I don't think that someone overseas can say to you, you're no longer...
It's a presumption under Section 24. You have deemed to have lost, and all that the adjudicator, the immigration officer, the adjudicator can determine that you did
Yeah.
lose.
But you have a right to enter the country to determine that.
Yes, you're right.
Okay?
To determine, but
Your landing all of a sudden is no longer not valid. It's still valid.
I know Section 24.
I think you're allowed to enter the country, and if they don't say anything to you, you are allowed to come into the country. I've had the consulates tell me, no problem if the client hasn't been here in 10 years and they came in, they turned around and sponsored a spouse, and all their kids were born abroad and they're married abroad. If they're in the country and they're working and they happen to get in, nobody asks them the question, they're fine.
That's not a story. The question is overseas, an immigration officer and a visa officer, also an immigration officer, says you come in to talk to them and they say you've lost your status.
What do they do, though?
They haven't determined whether you have or have not lost your status. Agree.
Yes.
But the fact is they are making the determination that you've lost it. That's what you're appealing from.
No, I don't think so.
That's what you're asking.
I disagree. Gary, we can agree to disagree on this. I guess we'll have to resolve it after, but I think that you are allowed to enter the country, and the only people that can make that decision is the adjudicator.
Bring it back to the ethical question. So would you be ethically correct in saying to the client, that determination, there may be a presumption out there. You may not be challenged on that presumption when you cross the port of entry, but you have the right to
Try to get in.
and come to Canada, and if nobody challenges you, nobody 27 reports you, you can continue to live as a permanent resident of Canada legally and lawfully.
That's my position.
What do you say, Richard Curlin of Lexbase?
I like Barbara.
Frankly, I believe that until an adjudicator pronounces on the individual case, you retain all rights and all privileges, period. An immigration officer posted outside Canada is not an adjudicator.
Barbara, any comments on that?
Charge the visa officer with theft for taking the visa.
Yeah. Now we know Barbara's opinion.
Thank you, Barb. Uh-oh, Gary's on his feet now.
No fist fights here, huh?
Making suit against the carriers for preventing the individual boarding the vehicle based on the contract of air carriage. So there are plenty of rights.
And then, Richard, Gary's getting ready to hoodwink you right now because he's going to tell you that Section 424 says adjudicator or immigration officer, as the case may be, right, Gary? Unless.
Where a permanent resident is outside Canada for more than 183 days in any one 12-month period, that person shall be deemed to have a abandoned Canada as his
Unless.
place of permanent residence, unless that person satisfies an immigration officer or an adjudicator, as the case may be, that he did not intend to abandon Canada as a place of permanent residence. So you are deemed in law to have abandoned Canada, you lost it. You have the opportunity to come back to satisfy somebody, and with the greatest of respect, not to be too much of a nitpicker about it, the concept that when you come back, you are unchallenged, you are home free, is very appealing. But given the way the government plays the game, you put yourself in jeopardy of being a G if you fail to disclose at the port of entry the length of your absence. Because at primary inspection, the customs people inevitably say how long you've been gone.
Oh, of course you cannot misrepresent, but I'll tell you, typically people, if they arrive in a car, they don't ask the same amount of questions as they do at the airline.
We can't let the record reflect that as long as they haven't caught you.
No, I don't mean that. You could not. Clearly, you have to tell the truth. But, you know, I guess the question is, do you get there and say, oh, by the way, I had something I wanted to tell you. I've been out for 10 years. I haven't been back. And, you know, my mother does this, my dad. You know, are you obligated?
Forgive me,
I don't
David,
think you are.
But isn't the question you started this with, David? That what do you tell your client? Can your client use the visa, or is the visa, ethically, can you tell your client to return to Canada using a visa based on the fact that he's been outside of Canada more than 183 days? Is that the issue that you initially started this with?
Yeah.
I think you can.
Especially if I could-
Yeah.
Especially considering the fact that I've had long experience as a port of entry immigrant or customs official at both a car and an airport, and I know very well that that question is not asked except on an E311, which you fill out as everybody does on the plane, and it asks the question, how long has it been since you left Canada? It does not ask a cumulative question, and very few primary inspection officers ask the question. It goes to the point, do you have to
Voluntarily tell everything.
where?
I don't think you do. I've been told by the consulates, different consulates, you do not. Barbara is in agreement with me? I don't agree.
Well, I
You can't actively mislead, for sure.
wouldn't tell them to come forward and say it, but I think you gotta recognize the case law
Yeah.
says material omissions.
Yes. But you, I would,
I'll get to the question again, just to follow up on Howard's. You get this phone call, you say to the client, Section 24 says that you have an opportunity to hear in front of an adjudicator or is it immigration or senior immigration officer and contradict that. And they say, well, what happens if I just come to Canada? Can you tell them, well, here's what's practically going to happen to Canada?
I think you have a duty to tell them that what if you told them, no, you can't come to Canada? That's incorrect information. They are entitled to attempt to enter Canada. So I think you have to give them the full story. You can attempt to come into Canada. You cannot lie, mislead, no material reps. And this is a law. So I guess, I mean,
You do have an obligation to
I don't think Barbara's saying that. Are you saying that your client should get to the border and say, I've been out for 3 years and this is why? No.
I think it's the adjudicator's decision, but I would tell them if they're asked any questions.
Yes,
But
clearly.
I wouldn't tell them they have to offer. They're already a resident, they're not seeking residence.
Form asks when you leave Canada.
That's
That's
it.
more document.
In concluding this thought, this is a rather important point, so let's just go through it again very carefully one more time. The client asked me on the phone, they says, I've been out of Canada for 2 years, and you've asked all their fact situation, they still have a bank account, let's make it good. They filed some tax returns, and the children are still back in Thornhill or wherever. And so they said, can I get on the plane with the visa? I'm asking you as my lawyer, can I get on the plane with that visa? Or do I need to go over to the Canadian consulate and get a visitor visa? Let's assume it's a visitor, not a visitor exempt national. And so that's what started this whole thing, I take it, right? Okay, so the answer then is, in my mind, I would tell my client what I thought factually his position was under Section 24, if it came to the point of making a determination, how much ammunition, on the balance of probabilities both ways, it looks like a good case or a bad case, but he can get on the plane with that visa if he honestly and sincerely believes that he intended to be an immigrant and that had left Canada for temporary purposes, and then fight it out afterwards in a process. And that's the end of it, right?
So he gets on the plane, he arrives at port of entry, and the immigration officer makes the determination, hey, you've abandoned. He hasn't had that phone call with you where you brief them on the facts of the case.
Right.
They take the immigrant visa and they issue you a visitor record, and they say, welcome to Canada, have a nice visit.
That they shouldn't be doing.
Then how do you get the determination?
There's a redetermination
Well,
process.
you'd be going to a proper hearing on that.
No,
The
no, they
manual says,
They don't. What they do in reality is exactly what Betsy says. They take away, oh, thank you, you've lost your residence, thank you, here's your visitor's visa. I just had that last week, someone come in.
I'm on that border committee for the Canadian Bar Association. They do one more thing. They try to get you to sign a thing that says that you voluntarily give up.
That's
your
right.
land.
Yeah.
That's right. They remandate.
There's a process.
but you're entitled to a hearing.
Yeah, I know.
You've already abandoned your residence. They're actually forcing people to abandon their residence.
It's a topic of discussion right now with Pierre Boland, and the answer is going to be is that they're looking at it and looks like they're going to issue an instruction, basically to the ports of entry here in Ontario, that this is not to be done. The person has to be also advised of the right to counsel and the right to
A hearing.
have an inquiry.
There is also a process that once that's done, there's I think it's called reconsideration of loss of status. It's at the Inside Canada post. Maybe it's Vegreville, they do it now. Your redetermination, yeah. So you submit it and with all the facts. But I mean, it's almost like tricking people to give up their residence, which they do regularly.
Your bigger problem is not when they do this at the border, because the person's here and you can go and get a lawyer and get an inquiry appointment. It's when they do it in
Yeah.
the visa office
Yeah.
and they take your Form 1000, how do you get on the plane then?
Then you can't get on the plane.
All the time.
Okay.
Different issue.
You might want to take that up with Jean afterwards.
I think that actually, as a follow-up, I think that the Department of Immigration needs to consider
You're never getting home.
their own ethical rules, what they do. That's a problem. Sure.
You've got to be really careful before you tell someone to show that they can show up, and they have to tell the truth. They're asked, is that you have to ensure yourself that you think they are.
Yes, yeah, you have to make sure, like for example, the example Howard gave is actually a pretty good case. If they have a family and a house and a wife in Canada, that's a good case. We're not talking about cases like that. We're talking about cases usually where the person probably is not. They've been away for a long time and have no ties. So I guess you have to tell them what the law is, and technically they're allowed to get on a plane, but they've deemed to abandon. They'd have to prove it, and their status could be taken away from them. So decision they have to make.
One last comment. Is that an additional wrinkle to it? What if the case where a client applies for returning residence permit, the client's out of the country for, say, 2 years, and realizes, oh my God, I want to go back to Canada, I need another country for this amount of time, makes an application and gets an answer, you're not getting your returning residence permit, it's denied, and it's our opinion that you're not a permanent resident, given your absence. So in that case, you have a written opinion by a visa officer, I would think that it'd be a clear case where the person is not a permanent resident.
I don't think so. I think it's just a separate application.
That's actually not how that letter reads. That letter continues on to say that the final determination is made by an adjudicator at a port of entry.
Actually, I did get a letter which did indicate that we're refusing to return residence permit, and it's our opinion that you're not a permanent resident, you're no longer a permanent resident.
And that's all it is. Their opinion.
So it's an opinion rendered by
Doesn't matter.
No.
An adjudicator will make the final
That's an
decision.
opinion on that application form. That's all, not on the status itself.
It's not prohibitive. It's not a final determination.
Okay. Okay.
Thank you.